So, on to the legal section. Hopefully I won't scare you too much today because Sally has actually already covered a lot of the scary bits that I normally cover. So today I'm hoping that I'm going to speak to you about some of the legal side of things that is not as scary, because do you all agree, guys, that what Sally's talked about today with all of these regulation changes and the things that you as landlords need to do and we as agents need to do is pretty phenomenal? It is really, really phenomenal, and it is growing, and it is growing, and that list is going to continue to grow over the next couple of years, we strongly believe. So I'm going to take it a little bit back to basics and talk to you about a few things here that most of you, I hope, will either know or have at least heard of. If you've heard of it, we're in the right room. If you know it, you should be up here. So we're going to talk about inventories. Why do we need an inventory, and what's the purpose of an inventory? Lots of landlords say to us, don't they, guys, at the front end, oh, I don't need an inventory, there's nothing in there. Is that true? We're going to talk about eviction notices. Does anybody know in here how you evict a tenant on a AST? What notices do we use? There's 2 notices that you can use for eviction on an AST. If you don't know what those are, you will do by the end of this section. We're going to talk about licenses, tenancy agreements, good old tenancy agreements. We're going to talk about rooms for rent and HMOs and some of the new changes that are coming into force. We're also going to talk about licensing, because I think licensing is going to be a huge thing over the next few years. It has had a massive effect on our business. Not necessarily in Wolverhampton, but most definitely nationally, there are areas where licensing now is a huge issue. Liverpool is an example. I was speaking to one of the landlords earlier this evening, and I was advising them that Liverpool Council decided that they were going to license the whole borough of Liverpool, which meant 55,000 rented homes, no matter what the size, whether it was a 1-bed, a 2-bed or a 10-bed, required a license in order for you to let that property out. They made a huge mistake by doing that because they couldn't handle 55,000 applications. But they learnt their lesson from that, and they've now introduced another area in Liverpool called Sefton, and they're doing it again. So I think this is going to come into our area, and it has done already in the All Saints area. But I think we're going to see it on a much larger scale. I'll try and whiz through everything today so that you can get a good understanding of what we're talking about, and hopefully leave some time for any questions at the end should you have any burning questions. So inventories. Do we all know what an inventory is, first and foremost? Does anybody here not know what an inventory is? If you don't, put your hand up. Do you know what the inventory is used for? What is the purpose of the inventory? Sam, let me pick on you because I know your name. What do we use the inventory for? What's the purpose?
To compare the state of the property and the contents. You want people that don't move in to what the state of the contents are.
Okay, so what happens if you don't have an inventory? Gentleman behind. For deposit damages. So is it true then when a landlord says to me, or to these guys at the front really, because these are the ones that put the application to the landlord and ask them what it is that they need. Is it true when they say, I don't need an inventory, the property's unfurnished? Does anybody here believe that you don't need an inventory if the property's unfurnished? So what we say to landlords is, so do you not mind if the tenants take all of your internal doors when they leave? Do you not mind if the tenants have painted the bedroom, number 2 bedroom, gloss black on the walls? Is that okay with you? They've not damaged anything and there's no furniture, but it wouldn't be okay because it will still have a cost to you to repair or replace these items. Inventories, I actually would go as far as to say, if you are taking deposits and you are not having an inventory, you're pretty much wasting your time. I'm being honest. The only thing you can attempt to claim from that deposit would be rent arrears, because you have no evidence of anything else, any damage, any changes, anything that's not rent arrears. So if you are taking deposits, please make sure you are carrying out an inventory and ensure that you are working to the requirements of the deposit registration providers. Because remember guys, we've had deposit regulations in play now. Housing Act 2004 first brought them out, became mandatory in 2007 that you had to now legally register a tenant's deposit on an AST. And if we cannot come to an agreement between a tenant and a landlord, what we then have to do is send it to an adjudicator who's never seen your property, never met you, doesn't know that you're a good landlord, doesn't know that you provided a great property to this tenant, and they don't know the tenant neither. So what they will make a judgment on is merely the evidence that is placed in front of them. And that will be an inventory and a checkout. And if you have one of those things missing, you're not going to be awarded the charges that you are most likely entitled to. Deposit registration and the law deems a deposit as the tenant's money always. And so it's down to the landlord to prove they are entitled to a claim on that deposit. It's not down to the tenant to prove that you are not. Does that make sense? We've had some real silly cases with inventories where I feel a landlord should have won an apportionment of money, but they haven't. I'm going to give you just a very small, quick example. A shower cubicle, walk-in shower cubicle, it has a door, would we all agree? Do doors have handles? 9 times out of 10, you would think so. Because the handle wasn't listed on the inventory and the handle was missing off the door, they didn't award the handle replacement for the door because the handle wasn't listed and there wasn't a photograph showing there was a handle. So the point I'm trying to make here is they need to be very, very detailed. They need to be, even if you've got a blank room, even if you've got an empty room, you've still got to document the carpets, the skirting boards, the wall, the ceiling, the light fittings, the window, the curtains, anything that's in that room. It can still be quite an in-depth document. And you also must make sure that it's factual. There's no point going in and saying this is great because I'm the landlord and everything's fantastic and it's all excellent and it's all brand new if it's not. So firstly, have a system to follow. If you're doing these things yourself, landlords can do their own inventories. I'd recommend that they don't because they're deemed as a little bit biased. So I'd always recommend third party, but you can do your own if you know what you're doing. So firstly, have a system to follow. Photos. Let's go back 10 years, like Sally said previously. When we were doing this 10 years ago, when I first started with Sally, we didn't need photos. There was no need to have photos. It was just a really good, detailed, written description. But now there's smartphones, there's iPads, there's this, there's that, there's the other. It's so easy to include photos into your inventories and checkouts. And you can't really argue with a photo of something. If there's a big stain on the carpet, you can't argue with that. So photos. You need to make sure that your tenant signs the inventory. Because if you have an inventory that's unsigned and you can't provide evidence that you provided this to the tenant, gave them the relevant time to amend or make any changes to it, then it could become invalid at the end of term, and again, not worth either what you've paid for it or the time that you've spent carrying it out. APIP is the approved professionals inventory providers, which we took a course on and became members of just to better ourselves and to make sure that we're up to current standards. We actually outsource ours. No, we don't. We did outsource ours, but then we stopped doing that because we had such high volume of inventories, checkouts and inspections. We employed a full-time clerk who carries out all of ours for us. But she's up to APIP standards, so she knows what she's doing. I've just explained to you the purpose and what an inventory is designed to do, and I've also just explained to you that there is no deposit negotiations to take place if you don't have them, because you have no evidence. And there's one word that I will always put in a landlord's mind when dealing with deposit disbursements is the word betterment. Have everybody heard of betterment? A landlord is not allowed to be in a better position than they were at the start of the tenancy. So, for example, if there's a carpet and it's got an average lifespan of 10 years, the tenant's been in there 5 years, it was down 2 years prior to that, it's had 7 years of its expected lifespan, the tenant has put 20 iron marks or iron burns all over the carpet, You can't charge them for a new carpet. But what you can do is charge them the difference for those 3 years that you would have left. So for example, if a carpet that you were going to buy was £100, you'd be able to charge them 30. Does that make sense? You have to apportion the amount that you're claiming from the tenant's deposit to be fair and to not put you in a position of betterment. Any questions on inventories? I told you this really isn't scary. Okay, excellent. Yes, of course you can, sir.
Therefore, in terms of deposits, what percent of deposit should you take because the deposit might not cover?
Absolutely. Well, that's a really good question, because guess what? We've got another new piece of legislation coming in called the Tenant Fee Bond that we as agents absolutely love. At the moment, there's no limit on the amount of deposit that you can take. It is recommended that you don't go over 2 months, purely because you could be deemed as creating a premium lease, which is very complex and I won't bore you about it, but it could change the goalpost if you take more than 2 months. But with the new piece of legislation that we think will be coming out later next year, they are putting a cap on the amount of money that you can take as a deposit. The guidelines at the moment, they're saying in the proposed bill, is that it will be 6 weeks. But we actually think, and I'm sorry to be the bearer of bad news, that it will probably be reduced to about a month maximum. Now, our argument on behalf of you guys as landlords, on behalf of our agencies, it's just not enough. Because how many tenants don't pay their last month's rent? Oh, you've got my deposit, just take it from there. Well, no, because your deposit is for damages, cleaning, things that are, you know, normal in some tenancies. If we've just got 1 month's rent, we're very, very limited on what we can charge. So at the moment, I think most agents take an average of 6 weeks, or I believe we take a month's rent plus 100. That's something we've always done. But again, more legislation. So this time next year, I'll be telling you a whole new story, I'm sure. Okay, so on to something a little bit more.
One thought as well on the inventory.
Yes.
When people leave,
yes,
it's always a good idea to check that things work. Because if the bulbs are there, but they're all dead, they can be replaced. Or if the cooker doesn't work, washing machine or whatever.
Absolutely, really valid point. And also, we haven't mentioned, but I've told you the importance of an inventory. The checkout report is equally as important, because one without the other, you've still got no claim. Because you might have the evidence of what it was like before, but without the checkout report, you haven't got the evidence of what it was like after. So you need both documents to put a claim in, but very good point, Garth. And bulbs. Can you charge tenants if when the tenant moved in, all of the lights in the house had light bulbs? Can you charge them for bulbs when they move out? Absolutely. Why not? You can. And you will win that claim, because they should replace the light bulbs. I remember when light bulbs were like 30p, you know, them screwing things that you do, but now they're like £6 each. If you've got a house that's got, you know, 10, 12, 15 lights, we are now at £60, £80. Why should that be your responsibility if you provided the property with light bulbs? Okay, so more important stuff. So I asked you guys, do you know the 2 notices that you use to end a tenancy? This is one of them. Section 8 notice. What is a Section 8 notice? Does anybody here know what a Section 8 notice is? Okay, Section 8 notice is a notice that relies on one of 17 grounds under the 1988 Housing Act that allows us to apply for possession of a property under an assured short-hold tenancy. Now, the grounds are split into 2 sections: mandatory grounds and discretionary grounds. Now, what does that mean? Well, what mandatory means is if you are able to prove that the ground you are citing applies and all of the boxes, remember what Sally said to you earlier about paperwork and boxes being ticked, all of the boxes have been ticked and you have the right to use this notice and you're using it in the correct format and you've served it in the correct day and you've left the right amount of days notice for service and you can prove that you have done all of this, then you can ask for your tenants to leave. So 1 to 8 is a mandatory ground. If you get in front of a judge and your ground applies on that day in court, The judge has to give you a possession order. Now, I have a lovely gentleman here called Basil, who I went to court with a few years ago. Do you remember Basil? And we went on a mandatory ground. And it was Christmas time, wasn't it, Basil? There you go. And the judge in Wolverhampton Council felt so sorry for this poor tenant that we actually had turned up, Basil, myself and a colleague, we turned up with the evidence that this tenant has not paid her rent for 4 months. I think we were at about 4 months by the time we got to court. 4 months. Now what they do is they write to you and they say, please submit all of your evidence with your court papers, and they write to the tenant and they say, please let us know if you have a defence. And what they're supposed to do is, that's what they're supposed to do. If there's a defence, it's meant to be done before we are in front of the judge. So the judge can look at all of the facts and make a decision. Now what I'm telling you here is on a mandatory ground, the judge should and must award possession. Now on this particular case, the tenant turned up, got the free advice from the lovely people that sit at the courts helping these people for free. And she came in and she said, I did pay my rent on that day, they're lying. And we tried to say to the judge, but sir, she should have provided... No, I will not have you talking in my court. I hereby give you 14 days to provide me with that receipt. So we were sat there and we were like, no, this is not right, but you can't argue with the judge. We tried, didn't we, Basil? But I nearly got done in contempt in court. I was actually really scared. You can't argue with them. So what you're probably thinking is 14 days is not very long. But remember what date we told you it was? Christmas. So 14 days wasn't 14 days. And also at the moment, the time that we are waiting for a court date in any application for possession is an average of 4 to 6 weeks. And it's actually teetering on the later, which is 6 weeks. So not only did he have to wait 14 days, he then had to wait for a new court date, which was another 4 to 6 weeks. And in this time, guess what? Did the tenant produce the receipt to prove that she paid the rent? Of course she didn't, because she never paid the rent. So we went back to court eventually and we got possession. So what's the point of this story? Because I'm telling you this is a mandatory ground. I'm just showing you how tough it is at the moment. And that was by doing everything right. 9 to 17 are discretionary grounds. What does that mean? That means that if you go to court on a discretionary ground, it's up to the judge on that day whether he gives you possession. So what we say to landlords and what our advice is and what most landlord and tenant lawyers' advices are, don't go to court on a discretionary alone, because you have no guarantee that you will win. You have no guarantee that you will get possession. And therefore, when we go on to talk about Section 21 notice, if we are on an AST and we are able to do so, it's much safer to use a Section 21 notice that the tenant really doesn't have as much defence to in a court of law. It doesn't mean, though, that you can't cite mandatory and discretionary grounds, because the one thing that we use this notice for most is rent arrears. There's lots of different things that you can use it for, and I'll show you a brief list that in a minute, but there's lots of different things. But the main one that is used in this country is rent arrears. So if your tenant is in 2 months rent arrears, or 8 weeks if the rent is due weekly, you can serve a Section 8 notice using mandatory ground 8, and what we then do is we bolt on 10 and 11, which are discretionary grounds in relation to rent arrears. Why do we do that? Why we do that is because mandatory ground 8 states that the tenant has to be 2 months in arrears when you serve the notice, first requirement, but they also must be 2 months in arrears on the day you arrive in court. So I've told you guys before about a how to rent guide that you give to tenants now legally at the start of the tenancy. What do you think that is? It's a Bible of telling them everything they need to know about a tenant. So what will a clever tenant do if you've only used mandatory ground 8? They'll pay 50 quid or a tenner on that day, and you're now below that mandatory ground. You've got nothing else to rely on in court. You may as well go home, because he's not going to award, because you are not meeting the requirements of mandatory ground. Now, we had a really funny case once. Well, it wasn't funny, actually. But be careful. Have any of you ever had tenants that have changed their standing order date? Has that ever happened to you? Yeah? On this case, what happened was we'd had a tenant that changed a standing order date. And the amount of money that they needed to pay was something stupid like £169.97. Well, of course, they came into the office and what did they pay? They paid £170, didn't they? Because we haven't got 3p change. So what that meant was the tenant was in credit by 3p. So when they started to not pay their rent and we got to 2 months, we were 3p short of the mandatory ground and we had to wait 3 months before we could apply for that. So bear that in mind. Never allow tenants to sit in very small credit, because if they do stop paying the rent, it really can extend the time that you have to wait before you can serve notice. And that 3p was the worst 3p of my life. So now, you guys don't know, but where's the property management? Farhan, what do we have in our office now? When a tenant is in arrears of, let's say, 1p, 20p, what have we got on our desk? We have an arrears pot and we take the 3p out there and we go up to our accounts department and we say, we're going to pay this tenant's rent. And they look at us and say, you really want me to bank 3p? And I'm like, yep, I do. Get it off that ledger, please, because we don't want it. Because we've learned from this lesson. Now, when you serve a Section 8 notice, none of you guys even knew what one was, so I recommend none of you serve one first and foremost. You either need an agent or a solicitor. But when you do serve a Section 8 notice, there's lots of things that you need to consider. There's lots of boxes that you need to tick. It needs to be served in a correct way. Prescribed form. You can't just get an A4 piece of paper and write Section 8, I give you 2 months notice. Doesn't work. You have to cite the grounds in full. You have to give the appropriate notice period. So as you can see up there, 1 to 5 are prior notice grounds. That means those grounds, if you are going to rely on them, the tenant must have been warned about prior to the start of tenancy. So of course, what do we do with those grounds? We put them in the agreement. They're in the agreement so that if we ever need them, they're in there and they've been notified. When you serve a Section 8 notice, you have to allow the tenant a 14-day grace period to pay up. So that's why it says you have to allow 14 days for them to act on that notice and pay you what they owe you. You also have to allow 2 days for service. 2 working days for service. Don't get the service days wrong because it can be very costly because your notice will be invalid. So 2 days notice, working days for service. So after we've served a Section 8 in general, 16 days later, if the tenant has made no payment, the landlord or us as your agent will be saying to you, we now recommend you act. And at that point is where we start looking at submitting an application to court for possession. Now some landlords say, why don't we give them a little bit longer? Have you just forgot what I told you, that we've got to wait 6 weeks for a court hearing? Do you really want to give them a little bit longer if they're not paying you? On average, if a tenant stops paying rent, and I mean stops paying completely, you are on average looking between 4 and 6 months before you get possession, because of the timescales that you have to follow with the process. So what that means is that you are without rent for the whole of that time, unless you have opted to take rent guarantee, which I recommend all of you do. I really strongly do. Because not only will that guarantee that you've still got your rental income coming in, but it covers all of your legal costs. Does anybody know how much the court fee is at the moment? It was, again, let's go back in time, just 1 year or 2 years, it was £175. It's now £355. They've nearly doubled that cost alone. So you're not getting no rent in, now you've got to pay the court fee, and then if you don't know what you're doing, you've got to pay a solicitor to attend as well. Now, we wish a solicitor would cost £355, but you're probably looking somewhere in the region between £600 and £1,200, depending on attendance at court and how good they are. So guys, if you haven't already got rent guarantee, if you haven't already got these things covered, look at it. Look at it now and look at it at your next let if it's not available to you now. Because trust me, I am experiencing this frequently. Not every tenant, but when it does happen, it's painful. And it really is. And that's a landlord's most vulnerable time because they're angry, they're frustrated. And then guess what? We've got Farhan then ringing him up going, hi, you all right? Yeah, I'm great, Farhan. Boiler's broke in this property down the road. Well, I'm not fixing that. She ain't paid me no rent for 3 months. I'm sorry, but you've got to. You're telling me I've got to fork out £1,700, £2,000 and she's not paid? Yep. Because if you don't, they will defend in court with the non-repairing claim. You do not want the tenants to have any defence in court when you get there. Think of arriving in court as a privilege. You've already waited 6 weeks. You don't want there to be the case where we were. You do not want the tenant to have a defence. So I'm sorry, guys. Sorry, landlords. You do have to maintain your repairing obligations under Section 11 of the Landlord and Tenant Act 1985, even if the tenant is not paying rent. And I know that's the point where you probably most likely don't want to do it, but it's actually the most important time to do it. It can be served by hand delivered, but please make sure you've got evidence of this. And if you are hand delivering it, it needs to be before 4 o'clock and it's still 1 working day for service. Now, do you send it if you send it by post? Who here thinks we need to send it recorded delivery? Put your hand up. Yeah, most of you. Absolutely not. Because if your tenant is not paying the rent and they see a lovely letter pop through the door that's recorded delivery and the man turns up and he says, "Can you please sign for this?" What are you going to say? "No, thanks." You're not going to sign for it. You're not going to sign for it because you know it's something you don't want to receive. First class post. Okay, because that is legal postage. I recommend you obtain proof of postage. So what we do is we photocopy our envelope, we attach it to the Section 8, and that's our evidence. Evidence it, but first class post is the best way because they cannot deny receiving it. So again, recorded delivery is not the right way to do it. Any questions on Section 8? I know that's quite a hefty thing. Yes, sir.
Is it wise to back it with an email? Because some emails you can get proof of it sent and read.
Yeah, well, again, this is another thing that they're so far ahead of every other regulation, but they don't seem to have caught up that we've now got emails. And emails are fantastic, they're quick, they're easy, there's no need for 2 days service. There's no actual case yet to say that notice served via email has been stood up in court, it is valid. However, what we do is we do send it via email, but we still back it up with the post. Because if you do it via email and the post fails or something, if you turn up at court and say, "Look, here's my evidence, there's the email, date, stamped and time, sent to that person, you know, they've received and responded to all other emails, I believe they've had it, and here's also my evidence of postage," the judge will look and he'll think, "You are not lying, you're telling the truth." There's no harm, absolutely not. But one of the things I would recommend is if you are going to be communicating with tenants by email, get their permission to do so and get an email address where they give you permission to talk to them through. It was really funny actually because we served something once and I can't remember what it was, but I found it hilarious. The tenant denied receiving it, but they'd responded to the email with a question that I'd asked in it. So I was like, how did you not receive the attachment? That was it, there was an attachment. We didn't get that one. But you answered the question within the content of the email, so how did you not get it? Any other questions about Section 8? Yes, Tony.
Loss of rent normally covered in your property owner's insurance?
No. This is another big myth. A lot of landlords don't believe that they're covered for loss of rent in their insurance. Loss of rent in an insurance policy, I'm not going to say categorically, but normally means that if your property becomes uninhabitable and you have to rehouse your tenant or your tenant doesn't need to pay rent for a period of time due to something that's happened which is insurable, they will cover your loss of rent for that period. It doesn't mean if your tenant doesn't pay, Tony, we'll pay it for you. Because don't forget, your insurance hasn't assessed the criteria of the tenant. It's assessed the criteria of you as the landlord and is based on that as such. So if I took car insurance out, they're basing it on my no claims, they're basing it on my length of driving, they're basing it on my age, now that I'm older, they're basing it on everything to do with me. So if Preet then wanted to drive my car, who hasn't passed the test and everything else, it wouldn't be fair for her to get in the car and say, well, I'm covered under Dawn's, because it's two very different things. So a lot of landlords believe they are covered for it in their insurance, but I would be very surprised and I'd say it will be very, very minimal if you are. Just just so that you can see, these are the grounds that we can choose to pick from in order to use for possession. So as you can see, some of them are not all horrible. So for example, ground 5, I like that one. If the property was rented to a minister of a church and the minister ended his, whatever he does, ministry, and that property was in relation to that job, you'd use ground 5 to end that tenancy. Ground 7, if your tenant dies, don't think you get possession of your property just because they've died. It doesn't happen like that. You've still got to go through the process of obtaining possession. The easiest way to obtain possession when a tenant has died, if you are unfortunate enough to have a nice tenant that's died, that we have, is through their next of kin and ending it via negotiation. But you have to make sure that the person that you're dealing with is the executor of the will and has the power to do so. Now, just because your tenant dies, it also doesn't mean that the rent due dies, of course, because if the tenancy has to continue, then the rent is still due and the estate would be responsible for that amount. But the easiest way when a tenant dies is just do it by negotiation, arrange to get the tenant's stuff out of there and end the tenancy by way of deed of surrender. This can actually be a really big problem. We've experienced it, haven't we, Farhan? When tenants have died in the past and you don't have their next of kin and you can't make any contact, and it can be a problem. And then here we've got the rent arrears ground 8, 11, 12 is a breach of tenancy. But as you can see, the majority of them, 9 to 17, where some of these are actually quite serious, are discretionary grounds. So moving on, section 21 notice, a little bit of a nicer, easier notice to use. So this is what I call kind of like the non-default notice. So this is used when you just want to gain possession, but your tenant hasn't done anything wrong. So one of the most common scenarios might be you want to sell. You've been a landlord and now you wish to sell the property. So you need to give the tenant the required notice to obtain possession of your property to allow you to market it for sale. You'd use a section 21 notice. Huge changes have happened to the section 21 notice, and Sally touched on it earlier with the Deregulation Act. So since the 1st of October 2015, massive changes have taken place, and I haven't got time to go through them all with you, but I'm going to cover some of the key points here. 2 months notice has to be given, and it has to be 2 clear months notice. So 2 full months notice. Minimum. You must remember to allow the time for service. 2 days if it's by post, working days, 1 working day if delivered before 4 p.m, hand delivered. You can give more than 2 months notice. So for example, you could give 2 months and a week, or you could give 3 months notice. But be careful, because with the changes, what they've done is they've put an expiry date on a section 21 notice. It's now only valid for court action for 6 months. That's 6 months from the date of service, not 6 months from the date of expiry. So by the time the notice has expired, yeah, Farhan's smiling at me because we were talking about this today. Once that notice has expired, you as the landlord have only really got 4 months to act, because 2 months have already passed, which is the notice period you've given to the tenant. 4 months to make an application to court for that possession order to be invoked. So they've really restricted this now, whereas prior to this, the longest known section 21 that was successfully acted upon was issued 6 years before they went for possession. Now, do you think it's fair if you serve a notice on somebody and I say, I would like the property back in 2 months' time, but I don't take action for 6 years? It's a bit contradictory, isn't it? Because I've allowed you to stay now for another 6 years. So I do understand their reasonings, but this is catching many people out. Many people. I had to, because it's my job, operations director, go in and change every single process that we have to ensure we comply with this. And one did slip through the net when it first came out, and one of my property managers, who's no longer with me, served a section 21 notice 3 days too early, because you cannot serve it until the first 4 months have now passed, and the section 21 notice was void. So after the 2 months had passed, we had to serve another one and wait another 2 months. So as you can see, this is really important that we get it right. It's now a prescribed form. There are still 2 others still in use. But for me, we just use Form 6A now, because if I said to the staff, right, you've either got to use this one dependent on that, this one dependent on that, and this one dependent on that, there's a chance they might get it wrong. So we've just said we use Form 6A, and what we do is we make sure before we serve that notice, if we haven't already because they moved in pre-October 2015, we will send to them a copy of the gas cert, copy of the how to rent guide, copy of the deposit certificate, copy of the licence, and a copy of the EPC. Everything that they need in order to make that notice valid. If you haven't done all of that, I'm sorry, but you can't use this form and you cannot serve notice. Please, please do not fall foul to this. And this will apply with the EPCs that Sally talked about earlier if they're not compliant and at the right grade. Sally mentioned that 1st of April, we can't enter a new tenancy, so we can't move a new person into a property, and we cannot renew a tenancy if the grade is not E or above. But come 2020, we cannot let the property, or your tenant can't live in the property if it's not an E or above. So we've got 2 years to get our stuff in order. Please start now, because those 2 years will come round so quickly, and there will be a lot more legislation changes that you're going to have to keep up with. So that's something that's quite simple. Anybody here not looked at an EPC? Because I don't really think they're much use, if I'm honest. On an EPC, if you go on to, I think it's about page 3, it actually gives you recommendations on how to get from your current to your potential, and it will give you based on cost as well. So for example, if you install energy light bulbs, cost will be about £60 to £80, it will help. If you install a new boiler, cost will be £1,500 to £2,500, but it will help. Look at the recommendations to see what you can do that's cheaper first to see if that helps. But start working on that now. Any questions on Section 21 notice? Section 21 notice, the great thing about this as well is that there's not a need to go to court at the expiry date of it. So with Section 8, remember I said you've got to wait 4 to 6 weeks for a court date? With this notice, once it's expired, if the tenant still remains in the property, you do what's called an accelerated possession claim. It's an online claim, or it's a form that you send off to the court, and it says, I've complied with all of the rules, the tenant hasn't moved out on the date that the Section 21 notice expires, please grant me possession. And what they will normally do, if the tenant doesn't defend it, I'm going back to make sure you're doing your repairs, make sure we're doing our repairs, because if they put in a defence, you do then have to go to court. There will be a court date set. But if they don't defend, what will happen is you'll just get through the post a possession order, giving you the information as to what date your tenant needs to be out. Good, yeah? But bear in mind, sometimes judges get it wrong. Our lovely judge in Wolverhampton actually got one of them wrong because of the legislation changes I was saying to this lady here earlier. This is what we do, eat, sleep and breathe lettings. And what I do is eat, sleep and breathe legislation. Because it's my job, it's what I do, it's what I'm passionate about, it's what I love. That's what I do every single day. A judge at 10 o'clock in the morning might be dealing with an adoption case, a family civil matter. You know, they deal with various different things every day. They don't just deal with housing. So I like to stand here and say, actually, I know more than the judge. And in this case, I did. And he'd sent back, instead of a possession order, he delivered us a struck out of court because you've served it incorrectly. Actually, I hadn't. He just wasn't up to date with the regulations, and we wrote him a nice letter to say, please, Mr. Judge, could you reconsider your verdict based on X, Y, Z? And within a week, we didn't get a sorry, but we did get a possession order. So bear that in mind, guys. Even the legal professionals, the ones that are paid a lot more money than I am, still get it wrong because it's not what they do day to day. Any questions on Section 21 notice? Yes, sir.
I want to miss the point. Why would you go for a Section 8 when you go for Section 21 and not have to prove?
Because there's two reasons. If a tenant is in a fixed term, so let's say tenancy started January and it's a year's tenancy, so it won't expire until December or January of next year if we keep it simple. You can't serve a Section 21 to expire until the end of that fixed term. So let's say your tenancy started January, they paid their first month's rent, paid their second month's rent, paid their third month's rent. April comes, they don't pay you rent. May comes, they don't pay you rent. You can't use Section 21 notice because they're in a fixed term, and a Section 21 notice cannot expire before the end of a fixed term. It can only bring a tenancy to an end when it's had its fixed term. Section 8 notice can be used during the tenancy, and that's why the Section 21 is a non-default, because you've not done nothing wrong. I'm going to allow you to finish your contract, but I do need it back at the end. And that's why Section 8 can be used mid-tenancy, because you're doing something wrong. And I'm not going to allow you to stay for the remaining 8 months because you're not paying me. The second reason is as well, is that on a Section 8, when you go to court, you also look for a money judgment. So a judgment through the courts that says, Preet, Mr. Landlord, I hereby award you possession, and Preet, I hereby state that you are ordered to pay Mr. Landlord the amount of rent that is outstanding plus his court fee. And then you can pursue them for that money. If you go in on Section 21, because some landlords do prefer to use Section 21 if they can, just because they think it's a quicker process. If they're nearing the end of the fixed term, they will, but you won't get the money judgment. So it depends what's more important to you. Is it recovery? Because not many landlords always recover their losses, because if they haven't got any money or they haven't got a job or there's nowhere that you can do an attachment to earnings, you might be fighting a losing battle. So it might be quicker and more effective to use a Section 21. But I always think, we're landlords. You guys are sat here at 9 o'clock. You want to learn, you want best practice, you all want to share the same thing. Wouldn't it be great if Garth shared with you his experience of an awful tenant so that you didn't have to have him? That would be great if we did pursue them and we did get judgments against them to stop other landlords experiencing the same thing. Because what a lot of landlords don't do, they don't do that because they're like, thank God they're out. It's not my problem anymore. And what a lot of other landlords do is, let's say Garth's got a tenant and they're in horrendous rent arrears, and you come along and go, hi Garth, this Preet has just applied for a property through me. Would you mind giving her a reference? What's Garth going to say? She's fantastic. I'm really sorry to see her go. Oh, she's just had a baby, or she needs a bigger property, or whatever. She's bloody brilliant. But the fact of the matter is, he just wants rid of her. So she becomes your problem and not his. So as landlords, come on, go for the Section 8, get the money, do the judgments. Let's put these tenants on lists and let them have county court judgments for their failures so that other people don't suffer. Because wouldn't it be great if we had done a credit check on the tenant that you've just had that's got rent arrears, and actually it showed that she'd done this 3 times before, because each one of those landlords had put a claim on her credit file, and when we run the credit check, it actually showed. Because landlords aren't doing that, the credit checks are clear. So just bear that in mind, guys. As landlords, it would be good to know and share with others if we know. We'd love to create a blacklist, like, don't go by that one. That's a terrible one. And a lot of the Facebook groups and things like that actually do that. Within their community, they create a little list, like, Garth might say to you, hey, have you seen that tenant? Have you had him before? No, he's all right. But when you're in big communities, you can do that. When you're within a Wolverhampton landlord group, for example, it's most likely that 2 of you might have experienced the same tenant. Make sense? Okay, so rent arrears. I'm not going to go through this, but I just want you guys to know, as landlords, there is absolutely strict criteria that you have to follow as a landlord in order to comply with the legislation of rent arrears. And I say this because as an agent, lots of landlords want me to do things that are illegal, but they don't realise it's illegal. They're not saying don't go around there with a shotgun, but what they are saying is, I want you to go around there and knock on the door. I want you to ring their employer. I want you to be at their door at 8 in the morning when they're about to leave for work. You can't do that. It's not legal. Under the Protection from Eviction Act 1977, there's a massive thing in there called harassment. And you honestly cannot do this. Now, some people do, and they do get away with it, because you could go round. An agent definitely can't do this, because we're agents, we're professionals, we're meant to know better. As a landlord, if you've got a reasonable relationship, you might pop round and go, hi, you all right? I've just come to bring you this. By the way, why haven't you paid your rent? But just be careful. We have to follow this procedure. 7 days, it will appear on our report that they haven't paid their rent. Now, landlords also say, why 7 days? Because we can't take any action, really, until this point. And the standing order might not have come out, and there might have been a bank holiday. There's many, many reasons why it might be a couple of days late, but 7 days is really unacceptable. So at 7 days, We ring them, we email them, we text them, but we also write to them in an official format, 7-day notification letter. You haven't paid your rent, please contact us. Quite a nice letter. Not nice, but you know, soft. Week 2, the letter now states, you're now 14 days in arrears, you've not made a payment despite my previous letter. This is not good enough. The next thing you'll hear from us will be that we're taking you to court. Week 3, if we've got rent guarantee, at this point we notify the insurers, and then hopefully within a few weeks you'll get a payment. But week 3, what we do is we phone, we email, we write, and now within the 3rd letter, what does it say? Because guess what we're coming up to now, guys? On the 28th day, we're coming up to 2 months rent arrears, aren't we? Because rent's due in advance. So on 28th day, we're coming up to 2 months rent arrears. So the 3rd letter literally states, still not received payment. As of next week, we won't be writing to you anymore. We will be invoking the Section 8 notice. It'll be served, and we will be taking you to court for possession. And week 4, that's exactly what we do. We start the process of Section 8. I recommend you landlords don't be soft with your tenants, because if you serve a Section 8 notice, in some cases, what it actually does is just gears them up to see that you are being serious, even if you don't act on it. Because all we want them to do, let's be honest, is pay the rent, really, isn't it? We don't want to go through the hassle of kicking them out. We don't want to have to find another tenant and have a void period. But what we do want is for you to pay the rent. And if you're 2 months in arrears, we do have a problem. Communication is key. If a tenant's in arrears, great if they communicate with us so that I can feed back to you. Mr. Landlord, your tenant is in arrears, but this is the reason why, and this is the date they can make a payment, and this is what they've proposed. They're in financial difficulty, but they're talking to us. But don't let that communication and that emotional side for those that manage properties themselves upset or interfere with the action that you take. And I think we had a conversation about emotions and properties and letting to family and so forth. It didn't turn out very well, did it, Nick? But you had a rocky patch, yeah? And a potential to go in a really uncomfortable direction for you, really. So with an agent, the good thing is you don't have to do that because we do. And we will be as harsh as we need to be. Do you all know that there's 2 types of tenancies? I hope so. An AST and what I like to just call a non-Housing Act agreement because it just covers everything. So an AST is what you guys are all most likely used to using, and it's what we use if 3 things apply. The tenant is an individual, so they are not a company. It is the tenant's main and principal home, so it's their main residence where they live. And the landlord is not resident. Now that sounds really strange, but actually it's a really valid point, because if you've got a HMO and the landlord at that time is living in one of the rooms, is that landlord resident? Of course he is. So you cannot use an AST. In some ways that's good because you don't have to comply with all this Housing Act law. So there's no need for Section 8, Section 21s or any of the rest of it, deposit registration, you don't need to do it. But don't try and cheat the system and say, I'm going to say I live in room 1 just so I can use a licence because I don't need to comply with all the law. Because if it is an AST by default, no matter what contract you've used, the courts will look at it as an AST by default because the Housing Act was put in place to protect tenants but also give landlords easier access to their property back if they needed to. So don't try and cheat the system. Many people do get this wrong. If you're renting to a company, anybody here ever rented to a company? I know we do quite a lot of company lets. Thomas we actually rent a property on behalf of Thomas, so we rent it as the company and Thomas lives in it. So that's not an AST because we as a company are the tenants, so we are responsible for the rent, we are responsible for all of the obligations under the tenancy, but the tenancy agreement permits Thomas to live there under the company let. So it's not an AST. So that deposit in particular, we haven't registered that deposit because you don't need to. So it's really important to know the difference between the 2 tenancies to make sure that you're using the right one. Like I said, we're going right back to basics here. Things that fall outside of the Housing Act are holiday lets. You wouldn't expect a holiday let. I'd like it because if I went to when I go to Jamaica in May, if I can be put up for 6 months rather than 2 weeks in the Rio, I'm sure I'd love that. But It's not realistic, is it? So they fall outside of the Housing Act. Holiday lets are holiday lets. You need to be able to get people out quickly, so an AST wouldn't work. Student lets, now don't get this wrong, it's not student lets that you guys do, it's like the residents of uni. So the halls of residency wouldn't be let on ASTs. Agricultural lets, I don't think that applies to anybody here because we're all in Wolverhampton. Company lets is the biggest one. But there's also a funny little one that's in there, high and low rents. I find this one hilarious. But it's very relevant in London because if a rent is less than £250 per year, you can't use an AST. Now, if any of you are renting out your properties for less than £250 per year, let me know and I'll rent it. And probably do a rent to rent. No, not really. But the higher end of the market is if your rent is over £100,000 per year, which it won't be for us here, but in London it will, then it also cannot be an AST. So guys, look up these things and have an understanding about the contracts that we're using, just so that you know that you're using the right one, that we're using the right one, that you're just keeping yourself up to date. So there's the key factors down there. And in order to have any valid contract, you need to have three things: an offer, consideration, and acceptance. Bear that in mind. For a legally binding contract, there needs to be those three things. Okay, right, HMO rules are changing in October. Anybody in here a HMO landlord? I know you are, Sam. Any others? So there, Martin over there. Okay, this is a big one for me. In October 2018, they are going to change the mandatory HMO licensing requirements. This is going to affect you, Sam. 100% it is. So open your ears and listen. And anybody that's looking to buy HMOs or go into that market is really important. At the moment, the HMO mandatory licensing criteria is if 5 non-related individuals live within a property making up 2 or more households and the house is over 3 floors, it's mandatory licensable, which means you need a license to let it. And that license is you apply through for the council. Now, when we did our business model of HMOs, Sam will know this because he purchased when we were doing this, we purposely bought all of ours on 2 stories to avoid that. We still managed to get 6 rooms, very comfortable professional house shares, but they're on 2 stories. So they avoid the licensing criteria, the licensing cost, and all of the things that goes with having a license. Unfortunately, that's all about to change for us. Now, by the 1st of October 2018, you must have an application in to the license for a HMO mandatory license. And this is not just Wolverhampton, this is most definitely England. Is it UK? I don't know. But we haven't got anything. Anybody in here from Wales or Scotland? No, good. So it's definitely going to apply to all of us. This is going to have a huge hit on the market because there are a lot of are yours 3 stories, sir, or 2 story? So you're already in that field of licensing. And are they above 5 people? 11. Okay, yeah, just a little bit then. But this is going to have a huge, huge effect on a lot of people across the country. And what they're also looking at is minimum room sizes. I'm sure you've all heard of this already if you're in the HMO market. Unfortunately, whilst they've released the legislation about the story element being removed, they've not confirmed yet the minimum room size requirements. But what this will depend on, guys, are things like communal areas. If you've got a HMO of 11 with no communal area whatsoever other than a kitchen, the room size requirements are going to be bigger than if you had a living room, a dining room, and other areas for them to use. Now, Sally mentioned earlier one of the HMOs that we're selling used to be a 6-bed. We converted it into a 5-bed just to give a bit more communal space. These are the things you guys need to be considering because the more communal space you've got, the bigger the rooms can be. The less communal space you've got, and if you've got none at all, they're going to be really strict with this because they don't want to be restricting somebody in a room that's tiny like that and they've got nowhere else to move to. So this is really, really a big thing. So Sam will have a conversation outside or later because we'll help you with the application for the license and so forth. Agent licensing. No, it's not meant to say agent licensing, but anyway, agent licensing is also coming in. I've talked to you very briefly. At the moment, do you know that an agent can be anybody? A letting agent that gives advice to landlords and takes all the rents that we take, which must be millions of pounds. They don't have to be regulated, they don't have to be licensed, and they don't have to have client money protection. So what that means is they are free to hold millions of pounds of other people's money with no checks. Do you think that's right? Anybody using us here, we are Arla members. We have client money protection and have done for many, many years because we don't believe it's right. Because you are putting in our trust your most valuable possessions. We are holding a hell of a lot of money on your behalf. If we didn't have that and I decided I'd had enough of it here and I was off to Marbella tomorrow and I took all your deposits and rents with me, there's not a thing you as landlords can do. And you have to replace that money because it's, remember, whose money is the deposit? It's the tenants. It's not the tenant's fault you chose me and I was a dodgy agent. That's your fault. I'm sorry. You've got to put it back in. And this did happen locally within Wolverhampton about 4 or 5 years ago. And I had one landlord that had 15 properties with them with deposits of about £500 each. So he really was out of pocket, you know, thousands of pounds because he had to replace them. But anyway, moving on to licensing, we have mandatory licensing, selective licensing and additional licensing. This is about tenancy, property-wise, what we're talking about is licensing. What do you see is happening here, guys? The council are trying to get a hold of every property in the country to make sure they meet minimum compliance standards. And what they've thought is the only way they can do this is by licensing the property. So I like the logic, but I don't like the way they enforce it because they're not doing a very good job of it. But mandatory again means that there's no two ways about it. You have to have a license if you fall into a mandatory licensing criteria. Selective means what I talked about earlier with the Liverpool area. They select an area that's run down, that needs regeneration, that the properties are poor. They select a particular area and they make that licensable for 5 years. And when that's finished, they'll move on to another area. Now, they did it here in All Saints. And I have to give Wolverhampton Council its dues. They did a very, very good job because All Saints was in a very poor condition. It was very run down. It was not a very nice place to go, walk around, and the properties were of poor condition. They selectively licensed it. They made landlords improve their properties. They improved the area. They're now building new properties there, and the area is much better. They achieved what this was set out to do. Liverpool haven't done that because they're still struggling through the 55,000 applications that are sat on their desk because they didn't think it through. So of course there's not been any, well, they don't know if there's been any improvements in the market or in the sector or in the properties because they haven't even visited them yet. And they're 3 years into the 5-year scheme. So in 2 years, that scheme will finish and it is most likely that they haven't looked at all of those properties. So it hasn't worked. But this is becoming more and more frequent. Liverpool, Wolverhampton, Essex, several different areas are now becoming selectively licensed. So please do not fall foul of this. Because what did I say to you earlier? What can you not do? With a Section 21 notice, you can't serve that notice if you haven't got a license where one is required. So you can never get your property back. So don't fall foul. Additional licensing is again where they decide in a certain area what they're going to do is they're going to reduce the story level. This is what was talked about. They're going to reduce it from 3 to 2, but just in one area. That's gone. But what additional licensing might take place is they might say in your area, actually, we want any properties that are 3 or more non-related or 4 or more non-related to be licensable, and they have the powers to do that as well.
So selective licensing, you mentioned here.
Yes.
Is that for 5 years?
Selective licensing is normally for 5 years, and I think what they've done now is put a restriction that they cannot choose more than 40% of an area. Is that correct, Sally? So basically, when they did Liverpool, like I said, they did the whole of the borough, 100% of it. They are only now allowed to choose a 40% of that 100% area and make that selective.
So just for my own
Yeah.
benefit. So for selective licensing, what you're saying is that they take one area, they're going to selectively license that area and move on to another area 5 years later.
Yes.
And then you don't have to do any more selective licensing in that other area, or is that other?
No, because obviously if they've already selectively licensed it and it's worked, see, what does a license mean? What does it mean? Basically what it means is you have to have a gas cert and you have to provide that to the council. You have to have an electric cert, which don't forget is not a legal requirement, but yes, it really is. You have to be able to prove that you've got smoke alarms within the property, and you have to have a visit to the property to ensure that it complies with HHSRS. So all they're trying to do is make sure that the property that you're giving to your tenant is up to standard, but they're documenting it. So those that don't comply, those where you go out and there are no smoke alarms and there's 15 people living in there and the place is riddled with damp, they won't be granted a licence and they're therefore breaking the law. So if used correctly, it will get rid of the rogue landlords and the slum properties and it will increase property standards. Does that make sense? Yes, sir.
On a positive point, more people might know about organising a scheme of rent with confidence.
Brilliant, yes.
You are 5-star landlord,
Mhm.
you do get your fee for HMO waived.
Waived or reduced?
Waived.
Waived.
Yeah.
That's really great to know. I might sign up tomorrow. Now, I am actually, because I sit on a home stamp meeting with a lot of the councils, we are part of the Rent with Confidence, but we haven't...
It only comes out every 5 years or whatever.
Yeah,
You did have
but no, that's great. That's great if you haven't got to pay, because at the end of the day, they're like £500-600 now, aren't they? And guys, remember licenses. One of the key things to remember here, if you are buying a property that's licensable or you have a property that's licensable, they are not transferable. So if you have a license and you sell to Basil, he can't use your license, he's got to get a new one. So bear that in mind, guys, as well. Any other questions? It can be about anything. No? Excellent. Well, thank you very much.